case briefs, and so much more. LSData's got what you're looking for.
In 1986, the contested congressional election of the 8th District of Indiana found its way into the courts in the case of Morgan v. United States. Richard McIntyre, a Republican candidate who after a recount thought he had won by 418 votes, found himself unseated in favor of his Democratic opponent, Frank McCloskey. This unexpected turn came about when the House of Representatives conducted its own recount and declared McCloskey the winner by just 4 votes. A group of Republicans, disgruntled by the surprising flip, brought a lawsuit to court arguing that their constitutional rights had been rebuffed. The case was dismissed by the Court of Appeals. The underpinning of this judgment was the Elections Clause of the Constitution, which establishes the exclusive right of each House of Congress to judge the elections and returns of its own members. Previously, the court had laid out conditions that would allow for judicial challenges to legislative resolutions of disputed elections. Such grounds would exist if the House infringed upon due process or overstepped its constitutional power. However, this would require an individual interest that went beyond the mere determination of election results, a power that lies squarely within the jurisdiction of the House. It was on this basis that the lawsuit filed by the Republicans crumbled. Affirming the district court's decision, the Court of Appeals left no doubt that the legislatorial gap for judicial intervention in congressional elections was limited and largely unexplored. Once the House of Representatives had declared a winner, no other federal institution could dispute the choice. Thus, the courts declared the case moot, as they were unable to provide a meaningful relief for the plaintiffs. The saga of the 8th District's 1986 election had reached its definitive conclusion.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class.